Hi folks, I'm Anthony Wagner. I am with the Santa Barbara Police Department. I am the Public Engagement Manager, but I also have an expertise in cannabis policy. I'm a transplant from the city of the city of San Diego, where I was a planning commissioner that helped bring online the 14 legally conforming actors retail operation centers in the city of San Diego. So about a year ago, I came up to Santa Barbara to help institute the cannabis policy here. But the whole brains of the operation is Andrew Berman, who is our land use expert, and Tava Ostringer, who is our Madam City Attorney. I'm very lucky to have them because they make me look brighter than I actually am. So thank you guys for coming. We're glad that you're here. For those of you that may be in the wrong room, we are here for the informational meeting for prospective cannabis business applicants. So hopefully everybody is here for that. It's going to be a main chunk of this evening will be a question and answer period to where we can answer some of the questions that you have. But this will just give us a framework to be able to springboard into that conversation. So we're going to talk about the existing regulatory framework, the application process. Within that application process, the evaluation criteria, the public meeting itself in May or so, and then the final ranking, and then permit issuance. And then we'll get to what I think is the most important part, is answering your questions. So let's start with the regulatory framework. So the city of Santa Barbara, let's start with this. So after tonight, it will be prohibited for you to have what's called an ex parte communication or a private communication with the council members, with members of the commercial cannabis application team, with the city administrator or the city administrator permit evaluator. So it's within your best interest if you have questions that you ask them now, or you're also able to ask them in a public setting on Planet Bids. How many people have gone to Planet Bids already? Perfect, so a vast majority of you guys. So you can ask your question in a public environment, and that way everyone's privy to the question and the answer, and we feel that that levels the playing field so that everyone is at the same start line for this entire process. Anybody have any questions about that? Yes, sir.
Did you make up the cannabis application UT?
We were a portion of it, okay, correct.
And there's additional city staff.
Correct. It's safe to say that you probably should not communicate after this evening with any city entity. Your only conduit of communication after tonight would be through Planet Bids, to where you ask your question and everyone's privy to the question and everybody's privy to the same answer. Anybody else have any questions? Perfect. So December 5th, we created the City Council created a land use zoning ordinance that permitted locations. There was an operational standards regulatory ordinance as well. That basically is municipal rules to abide by. It was important for our city to maintain local control and not have the state be solely responsible for the best practices and protocols that will be happening within our city. So the council also approved limiting the location of commercial cannabis businesses to within the manufacturing zone for all of the components. So that's storefront retail sales, in which there will be 3 total: retail delivery, manufacture, distribution, testing, and indoor cultivation. And I don't know if I say this elsewhere, but the city does not provide for a distinction between medical cannabis and recreational cannabis. While you need to apply for that at the state level through an A or an M license, the city has the view that it has the same impact to the city, whether it be recreational or medicinal. So the City Council also allowed storefront retail sales of cannabis to occur at the commercial general and the commercial retail. And let's look at that map together. So the red is the manufacturing zone, and the green is the commercial zones where it's allowed. But this particular map does not show the sensitive receptor overlay. We'll get to that in a second. I would also caution that any property south of Interstate 101 could be subject to the California Coastal Commission, in which they also have jurisdictional authority. So this is what it looks like with the sensitive receptors. There still is a major geography available for what's now red in the commercial zones, and what I think it's fair to say is a pinched manufacturing zone. Now, this map is meant to be a help to you, but should you be in any of these areas that you're close, I highly encourage you to work with a land use entitlement firm or an engineer or a land use attorney to measure the distance yourself. Y'all don't want to get so far down the road to where you think you're far enough away from a sensitive receptor, but then you get all the way through the process and oh my gosh darn it, I'm 7 feet into the sensitive receptor. And I'll tell you, I speak from experience because in the city of San Diego, we had 1,000-foot distance between sensitive receptors, I think as well as other commercial cannabis business facilities. And it bit some people pretty heavily, and it was unfortunate that they put so much resource into finding a location, but they didn't devote the necessary resources to ensure that it was outside of the sensitive receptor area. Now, I just want to say thank you to a dignitary that's walked into the room. We have our Police and Fire Commissioner, Commissioner Parker, here with us. So thank you for being here, sir. So it's going to be a 4-phase application process. Phase 1, you'll have the application submittal. That originates from Planet Bids. The Cannabis review team will have an initial review and ranking. Phase 2, the applications are scored on the business plan, the labor and employment plan, the neighborhood integration plan, the safety and security plan, an air quality plan. Applicants scoring a minimum of 80% or 800 points may proceed. This also, we speak from experience. In San Diego, they had sort of a first-come, first-serve basis to where whoever was best at getting to the front of the line was the commercial cannabis operator that was doing business with the city. That did not make for a very good partnership between the commercial operator and the city. So that gives us an opportunity to grade applicants to see who would be the best neighborhood partner to ensure that their facility does not disproportionately contribute to nuisance-related activity in and around their establishment. It depends on your question, but let's wait till the end, and then just remember your question, and we will answer it accordingly. 4 phases to the application process. Phase 3 is a public interview. That public interview will most likely be in this room. It will take on the form or look or feel of like a hearing because there'll be public comment. You will be providing, for lack of a better word, testimony for the public to better know your business plan and city staff to make an informed decision on what candidate has the best merits for their particular plan. 4th phase is a final ranking by the, what is the PA again? I can't remember. The Permit application evaluator coming from the city administrator's office. So only commercial cannabis businesses scoring a 90 or better will receive a local permit or have the capability. The key word is may, because once again, there's challenges with you could receive a sufficient score, but you could be within 1,000 feet of another commercial cannabis business, and then there would be a tiebreaker. So here are some important dates. Of course, on the 1st of February, applications became available on Planet Bids. On the 22nd, of course, is tonight's meeting. And on the 30th of March, the applications are due to the city. Check with Planet Bids to see what exactly the time is to ensure that your packet gets in at the appropriate time. But it's safe to say don't wait till the last minute. If you're pushing the send button on the 30th, make sure you know when Planet Bids says the cutoff is. Pacific Standard Time, Eastern Standard Time, wherever you are, make sure that you are executing that process on time. And then towards May 30th, the city will award approval of commercial cannabis business locations. Those interviews, the sort of the public hearing will take place. Interviews will take place between April and May. So here's the application process. So everybody has been through Planet Bids, but you make sure you apply, that you interface directly with Planet Bids. That's, of course, accessible through our city portal. Everybody see that we actually have a website open now. So you just go to Google and type in City of Santa Barbara commercial cannabis. And it'll probably be like the first thing, and it's a landing page for the City of Santa Barbara website that has all of the information available for commercial cannabis businesses for the city of Santa Barbara, in the jurisdiction of the city of Santa Barbara, and then it has a springboard to Planet Bids as well. So every person applying to be a principal and or the landlord to operate a commercial cannabis business, or better known as a principal, must complete a criminal background check and a live scan review. We have just put on that website an additional live scan form that has all the correct numbers to make sure it gets routed correctly. So you'll have two forms for the live scan. One form is the form that was already embedded on Planet Bids, and then there is now an additional form that you can take in to the police department to start your process for live scan. Now, I'll tell you that we only have one live scan officer, and it's highly encouraged that you make an appointment so that you can use your valuable time wisely and that we can allocate resources accordingly. It does not. You need to have it done in the state of California, and it can be at a law enforcement agency. But you need to take the form, the live scan form that's now on our city website, print that out with all the right numbers and the routing, and take that to the agency of your choosing. Keep your paperwork because there's a lot of variables and crossed wires, and we want to make sure that you're able to keep everything moving in the correct direction. You'll also need a zoning verification certificate. Applicants were required to obtain that certificate from Community Development. That's 630 Garden Street, same place you'd go for the staff hearing officer some of you have been to ensure that your proposed location meets the locational requirements. Go to the counter and they'll help you accordingly. Staff planning counter. You'll need a notarized statement from the property owner that you would like to locate a commercial cannabis business facility on his or her property on that city form that is on the website, and be able to prove that you have consent from the owner. Once again, this goes back to San Diego, to where there were many HOAs or business HOAs, or many owners that were caught off guard that all of a sudden there was a commercial cannabis business popping up. So this provides you security as well, so you don't get the carpet yanked out from under you when you want to start your operation. An indemnification agreement for the city. Applicants must execute an agreement indemnifying the city against all claims, future claims, brought against the city as a result of the commercial cannabis business application or the application's actions associated with the commercial cannabis business application. It's also at the state and at the federal level. You also must pay an application fee of $5,600. Include a fee receipt for your application submittal. Payment must be made by certified check, cashier's check, or money order made payable to the City of Santa Barbara. Note that City will not accept cash, and application fees are non-refundable. One more reason why you want to make sure that you are not within a sensitive receptor. So here's the schedule of fees over a year or so. So $5,600 for that original application fee, $7,300 for a yearly compliance fee for commercial cannabis businesses excluding manufacture. The fee for manufacturer is a little bit higher because of the technical expertise to ensure compliance. That's at $9,000. And then roughly $7,000 for an annual permit renewal fee for all commercial cannabis businesses except for manufacturer. $8,600 annual permit fee for manufacturers, $840 minor permit fee amendment, and $2,800 for a major permit amendment, and then relocation about $5,000. I really encourage you to have that question at the end, and it's a longer answer than 15 seconds. So submittal and amendments. Submit completed applications via Planet Bids. The amendments and the supplemental information may only be added at the request of staff. Incomplete applications will be disqualified. I've talked to many of you on the phone, and the best money that you can spend is on a good land use attorney or an entitlement entity to help guide you through the process. The process is quite complicated, and it's complicated to ensure thoroughness of partnership with the city in the future. Here's the evaluation criteria. So the business plan has 400 points. Operations, best practices, your financial pro forma, qualifications of principals, 100 points, community benefits, 50 points, environmental benefits, 25 points, and then local enterprise, 25 points. So that adds up to 400 points for your business plan. Safety and security plan, 300 points. A detailed safety plan, a detailed security plan, and then enhanced product safety as well. Neighborhood integration plan, and the neighborhood integration plan is important to y'all because this could be used for a tiebreaker. How you will operate as a good neighbor, engage in community relations at the block level. A site plan shall be included for each potential location. Labor and employment plan, 100 points. We'd like you to describe your salary and wages, the benefits, your labor relations, and the ability for your employees to potentially collect a bargain. Air quality, 100 points. We'd like you to demonstrate healthy air for your employees, and then ensure no detectable odor off-site. Minimum scoring for advancement in the, I guess that's the second phase. Applications must achieve 800 points to continue in the selection process. And then we get to the public meeting. Once again, that will be here at this particular chambers. There we are. So Santa Barbara Municipal Code 9.44 is the regulatory ordinance that authorizes the city administrator or his designee to conduct initial evaluations of the applicant and to ultimately issue commercial cannabis business permits. Successful applicants will be able to make a presentation in these chambers to the permit application evaluator designated by the city administrator. And then the final ranking. The final permit application for the evaluator, only commercial cannabis business applications scoring 900 points will, or I should say may receive a local permit. Additional requirements for retail, you got to be 1,000 feet away from an approved or high-scoring cannabis retailer. Only three retail permits will be awarded. And then, of course, as we said, the neighborhood integration plan, that score will resolve a tie if necessary. Permit issuance. The permit evaluator will issue commercial cannabis business permits on or before May 30th, 2018. And we are to those questions. Who would like to ask the first one?
Before we start taking questions, I just wanted to, hi, I'm Andrew, everyone. I just want to lay a little bit of ground rules for the questions. I don't like rules, but just, the structure, let's say. I don't want to have too many people hogging the microphones. I want to try to bounce around, so if you can keep your questions kind of concise and respect everyone else's time. Staff, we're going to be here for as long as it takes to answer all the questions, so there's no real need to rush. We've got snacks in case you guys get hungry. I know you're here through your dinner hour. So I'm going to start with the question that you asked about the major and minor permits, and then I'll start walking around with the mic. And if you can speak into the mic, because we're going to put both the presentation and the video of tonight on the website, so you can go back and look at it later, or someone who couldn't come tonight can check it out. So the example of a minor amendment might be a revision to, say, the security plan, or a restructuring of the site plan in the business plan. Something that's more major would be, say, an expansion, and if you're taking the adjacent space and like doubling the size of your, that would be more of a major permit. That's it's modeled on the difference between major and minor in the coastal development permits, if any of you are familiar with that in the land development process. I would say in most cases, physical changes are going to be pretty major, and then like minor changes that are just revisions to your articles of incorporation or whatever else might be a minor permit or a minor amendment. So with that, I'm going to try to bounce back and forth across the room to make sure I'm covering spatially, but I think I saw your hand up, so I'm going to head back this way. Hold on a second. I want to get in the microphone.
The reason why we want to get on the microphone is we're recording it.
Okay, gotcha. I appreciate that. Throughout the presentation, you had made mention of, and it might be by virtue of your experience down in San Diego that you had made the comment, but it was if two people were within a designated area, and I know it's 600 feet here versus 1,000 down in San Diego, is that automatically, even if you had a successful bid, you got to 90%, you're at the public interview, is that where you're going to get to the tiebreaker right away no matter what? Because everybody's jockeying, obviously, for properties and things like that. Hi, Tava.
Josh. So the tiebreaker would occur if more than 3 storefront retailers received a score of 90 or better. We would take the top 3, and they would be issued the permit if they're above 90%. But if 2 had the same score, we would look to the neighborhood improvement plan, and whoever scored higher in the neighborhood improvement plan would get the permit. If they're 2 within 1,000 feet that are, say, they scored 90% and they're the top 3, but 1 is within 1,000 feet of the other, we'll take the higher scoring one, and the other one will unfortunately get knocked out. Or otherwise, if they're both scored the same, we'll apply the tiebreaker.
I'm going to take another question, sorry. I'll come back.
Thank you. On his note, does that apply? I mean, you know, we're looking at the orange area, which is M zone, that was developed in the early 1900s. They're all smaller buildings. It's very close to a lot of sensitive receptors. Matter of fact, about half of it is. Then you have the other quarter on the other side of the freeway. So what we're talking about is very few buildings that are available. Am I understanding that a manufacturer next to a testing facility has to be 1,000 feet away? If so, you're only going to have room for maybe 1.
No, that's not correct.
Okay,
The 1,000 feet only applies to storefront retailers.
Awesome. Thank you so much.
Yeah, I know we're sort of on our own on this sensitive receptor business, but I'm curious if we can get a copy of this map. It looks a little different than the map I pulled off the website yesterday, dated February.
The one on the website is accurate.
Okay.
They had, I believe, added to it, and it also has a disclaimer. And basically that disclaimer says is that it's the onus on you to ensure that you're not within that sensitive receptor.
I get that. I just thought it might be helpful to have this map. It looks a little more restrictive from what I'm seeing than the map I pulled off the website.
This is an older version of the one that's on the website, so I would rely on that one, at least for now. She's next.
Is there a new application that's required for the ranking in Phase 4, or is it the same application that's ranked in Phase 2 and Phase 4?
Always the same application.
Okay. And then is there any sort of ranking that takes place during the public hearing, or the score is going to be the same as it was from Phase 2 to Phase 4?
The permit application evaluator will be at the hearing, and he will be able to, or she will be able to use that information and take that as part of the final scoring and ranking. You look confused. Hold on. So the information, if the application gets an 80% or better, those applicants will be notified that they can attend the public hearing and the date and time. They will be asked to give a presentation on their business plan, their model. Basically, it's kind of a request for qualifications. If anyone has ever gone through that, you're just trying to establish yourself as the best applicant, and the hearing, the PAE will be able to ask questions. The public will be able to attend. They can make statements just like we do at public comment. That'll give some idea, I would imagine, with regards to neighborhood compatibility. So if you've chosen a spot where you have a lot of people coming to complain, that may be something that the permit evaluator would consider.
My question is, these sensitive receptor zones only apply to retail or all the applicant categories?
The 600 feet is from all sensitive receptors.
For all applicants?
All businesses.
Okay. And then the next question, what happens if after you've received your permit, a school opens up within 1,000 feet of your business?
The code, the state code says that it's at the time the permit is issued. So if something opens up afterwards, that's different.
You're granted
I think, well, because we would have a renewal process, we have an annual renewal process, we could look at that. But yes, it would be taken into consideration that nothing was there when you went there.
Thank you. I know that there's a limit of 3 retail licenses. Is there a quota or a number of delivery-only licenses?
No, there are delivery-only licenses. There are a number of delivery-only licenses are how many can fit in the zone. Correct.
Are the medical-only dispensary permits issued under the old ordinance, which I understand are no longer permits now, they're considered pre-existing legal non-conforming uses, are those taken into account for the 1,000-foot buffer of a commercial cannabis business storefront with any other storefront?
That's correct.
Hi. So if there's a business applying for multiple licenses on a single site, do you submit those applications for individually? So everything has to be submitted for, say, a manufacturing, and then the same type of information for distribution and so on.
Correct, because the compliance is different for every single one of them, and the scrutiny that needs to go into. Say, for example, you might be a wonderful and pristine retailer, but we want to know what your manufacturer capabilities are, or your distribution capabilities are. So we want a separate plan for each component.
But you wouldn't require separate indemnification agreements and separate live scans?
Correct.
You could use the same one for...
I wanted to follow up on my original question regarding the ranking. If you happen to get past, you were an applicant that was 914, let's say, another applicant is 912, but you're within that receptor of another applicant, within 600 feet of another cannabis retail commercial applicant. Are you then, let's say somebody else was a 910, and so they were below your 913. The 914 is number 1, 913 is number 2, and then you have number 3 at 910 because you were very close to the applicant that was 914. You're saying the other one that's 910 is going to get the other one, and you're precluded at that point.
I would say that the neighborhood integration plan would be the tiebreaker. So there will be varying points to assess the neighborhood integration plan, and is there a likelihood that 2 neighborhood integration plans could be assigned the same point value? Possibly, but I would think when you have many different people grading it, that you'll have a broad spectrum of scoring.
Okay. And now a separate question. What exactly does the public interview hearing comprise of? How many people are there? I assume there's a panel.
Well, the city administrator designee, the PAE, will be conducting the interview, but the interview is mainly the public's ability to better understand what entities are in close proximity to them and how that entity will integrate into the neighborhood and be a good neighbor.
Okay. And so is an applicant able to bring PowerPoints, et cetera?
Absolutely.
Okay. Just trying to get a lay of the land. Thank you.
And Mr. Webb, well, if the applicants are notified that they can proceed to the next phase, we'll send something out, and it'll be posted on what you can expect and what the agenda will look like.
I think it's probably safe to say that you're not going to be able to have half hour at the mic, that there'll be some standard and protocol to ensure timeliness.
I'm a manufacturer of medical topicals, and I'm wondering, is there a cap on those, or is it just how many we can squeeze into this very limited space?
There's no cap on
Okay.
wholesale activity. So that's distribution, testing, manufacturing, cultivation. and I'm missing one of them. But which one? Delivery. There we go. So there's no cap on wholesale activity.
So it's just whoever can scramble fast enough and come up with the money and find a place that a landlord doesn't allow you to do business in that very limited space.
That's
with
correct.
high zone problem places. Great, thanks.
Yes, I have. Maybe I got a math problem here, but I need your help. We're showing Anthony, we're showing the business plan at 400 points. Then we go to the next page, which is the safety and security plan at 300. Then we have the integration plan at 2, labor and employment at 1, and air quality at 1. That's 1,100 points.
It's possible that we did the math wrong on the PowerPoint presentation, but the application itself probably has if you found a discrepancy, the application itself, we've done the math, and the math is correct on the application itself. I don't know where my error is, so please forgive me.
Got it. All right, cool. Can I ask one more quick?
Yeah, please.
All right. On the live scan, we went in the day that it opened, and there was only one form that had been on the website, which is probably why you said there's an additional one that's been added. Do we have to go in and double check and make sure that that was done correctly? Because the ladies were kind enough to pull out the second sheet. I think they're the right writing codes. What's your opinion on that?
I would highly encourage you to make sure you have your copy of whatever paperwork you've done.
Oh, yeah.
And then to verify your copy with what's now on the website. That seems like an easy maneuver there.
Okay.
And I follow up to that question. At the bottom of the live scan form, it's the Department of Justice form. That's what's been added, and that's what you need to take, particularly if you do not go to the Santa Barbara Police Department. If you go to another agency, you must have this Department of Justice form because it has the correct codes so that we can get it over to and back to Santa Barbara. You want the live scan operator to complete the bottom of the form, and most live scan operators will require you to bring a second sheet so that they can just fill it in twice. Otherwise, you're going to have to pay for a copy, which is probably 5 cents, but make it easy.
22.
22
okay,
cents.
22
yes,
cents.
There you go.
So it's make sure you have the bottom of the form completed because that's what we're going to want to see. That's how we know that it got done.
Okay. Just as a humor elephant here for the room, you guys need a good laugh. Show up on time. Linda will not take you if you are 3 minutes late.
I just had a question regarding, will there be any licenses granted for the cannabis smoking lounge? I don't know if that falls under any of the categories.
No,
so
sir.
far.
The city does not currently carve out space for consumption on site in a retail entity. City of Lompoc does.
The procedure form has language that says the landlord could potentially go through the background check if applicable. Is the only time a landlord would have to go through a background check is if they are the actual applicant?
Nope. The landlord has to go through the background check along with the principal.
If they are a principal.
Let me let Tava so I don't. Let me let Tava answer that.
So if the applicant or if the landlord is also participating in the business as a management member, a responsible party, or the applicant, then yes, they need to have a live scan if they're participating in the business.
But if they're just a mere landlord and sign the consent only and have no role in the business operations, then no background check for the landlord, correct?
Correct.
What if the smoking lounge wasn't a retail, it was strictly consumption?
There are special permits with the Bureau of Cannabis Control, and currently in the city of Santa Barbara, there is no ability to consume at any other place than a private premise.
Okay. Thank you.
So
On the responsible parties background information, Teva, at what area in Chapter 944 does it define who a responsible party is? Because I've been trying to find that.
It's in the definition section.
And then also real quick, it says kind of at the bottom of the form, proof of residence. So does that mean you have to be a Santa Barbara resident, or that's a little confusing? What does that mean?
No, it's just so we know where you live,
Okay.
so we can come find you, but also so we can make sure that you're also a California resident.
So you have to be a California resident to be a responsible party.
Yeah.
Oh.
Hi. Can you talk more about the local partner qualification? So maybe specifically, like, what would an ideal partner look like?
I think that's more or less a business proposition that would be a business decision more than it would be something that city staff could answer.
Yeah.
Okay. So sorry. Would you be looking for someone who has experience? If I was going for a manufacturing license, would you be looking for someone who had cannabis-specific manufacturing experience, or would you be looking more for someone who had that experience outside of the field, or can you speak to that?
I can speak to the fact that if you are operating a closed-loop manufacturing facility that involves a whole lot of chemistry, it would probably be a good idea to partner with someone that has expertise in that, and that you're able to demonstrate what that expertise is, whether it be graduate work in chemistry or certification or whatever it is that shows that that person is qualified to start mixing chemicals.
Yeah, hi. Does the location certification evaluate the sensitive receptor?
Does city staff verify the sensitive receptor? Yes.
Location certificate, does that evaluate the sensitive receptors? Like, if you get your location verified, does the receptors come into play?
And I'm going to have Teva be able to answer it, but the zoning verification is zoning verification, and the fact that you say it's 600 feet away, but that still is going to be checked. Go ahead.
Yeah, the zoning verification certificate includes on the form of the proximal distance to the closest youth center, school, whatever the sensitive receptor is that's nearest. So city staff is taking a look at it in that phase. Of course, that's not per se perfect. If there's a licensed daycare that's not been mapped by the city and that comes out through the permit process, as long as that licensed daycare is older than your application, then that's valid and not what the city's map has said. So we're trying to update it and make sure that we have every potential sensitive receptor on there, but I can't promise that it's perfect.
Yeah, that was the stickiest wicket back in San Diego. The fact that all of a sudden a sensitive entity would come out at a public hearing and say, hey, you didn't find me until now, but I'm here. And sometimes that was valid, and that blew the application out of the water.
I hope I didn't miss something by not listening, but I think I just heard that the child care centers need to be there before we apply. So if
They
somebody
need to be licensed.
Yes, I mean. So if somebody gets a license and opens up after we apply, not get the permit, but actually apply, then it does not. It's not an issue for us.
It would be the same question that the gentleman had before of another sensitive receptor. Same exact answer, which would be, I don't want to use the word grandfathering, but Teva probably has a fancier word for it.
But I think that answer had to do with the permit. And what I'm saying is, I think what I just heard is that it's at the application, which is a very distinct difference. As you know, all over these cities in California, it's an issue in the game various players are playing is to open up daycare centers and open up little private schools after their competitors apply. So I think that's an important clarification. If we can get that tonight, it'd be great.
It's by the It's by license. It's the date of issuance of the license. So that scenario that you've described is theoretically possible.
Yeah. And that's consistent with state law.
Yeah. You had a question?
Thank you. My question is regarding delivery only. Does phase 2 to 4 apply for delivery only? Do we have to go through the ranking process if we are delivery only?
Correct. You are just the equal in the city's eyes as a commercial cannabis business component.
Okay.
Regarding the security plan requirements, I believe the regulations state that 24-hour security will be required on site unless otherwise approved by the police chief. Does that mean your application should assume 24-hour security and plan for it, and then at some point that may get changed in the process, or is there an opportunity to discuss it before we actually submit these?
Yeah, there's an opportunity for you to discuss it before it's submitted, but I will tell you that we are within an industry that's brand new, and there's so many different variables that we're not able to account for, and we don't have any data that points us in a particular direction until we operate. So does that have the capability of being relaxed in the future? Sure. Is it the position of the Santa Barbara Police Department that we believe in the premise of ensuring that a security entity is there 24 hours? Absolutely.
Okay, so the safe plan would be planned for 24 hours. Maybe it gets relaxed later. But
Correct.
Okay.
Yeah, and that's for all the components. That's not just for retail.
Right. Okay. Thank you.
Follow-on question to the map and the disclaimer that your map might not have all licensed businesses. Is the ordinance written so that it's karate schools and ballet schools, anything that's licensed that has a child activity, or is it just schools and daycares?
I want Tava to answer that because it's a legal definition of minor-oriented facility.
So it's anything that's primarily youth-oriented. We've tried to find everything we can. I suppose if there was a karate school we didn't know about and it served primarily youth, that would be considered a youth center. The code section defined that also includes arcades, so it's a pretty broad definition. There has been a question, I know, with regards to sensitive receptors for youth centers that have been identified in the map, and particularly with regards to facilities owned by our Parks and Rec department. And we've consulted with the Parks and Rec director. She has identified those facilities as primarily youth centers. So those are the ones, that's why they're there. We give deference to, obviously, her opinion and how those facilities are used. And so that's why they've been identified on the map.
Okay, regarding the air quality plan requirements, obviously demonstrate is sort of a wide open term. Do you need to actually have like a professional assessment of the air quality within your facility, or is this more like explain to us in reasonable terms why you believe the air is clean in your facility? I
would defer to Andrew because Andrew has the most expertise in that.
I would say it depends substantially on what your line of business is. If you're doing something that's, say, like indoor cultivation, where you might have, extraction of oils, where you might have concentrations of odors, then you would be exposing either employees to or nuisance odors coming off of site. Then we'd want to see some robust analysis of, parts per million, parts per billion, that sort of thing. Not parts per billion, probably, but in a retail storefront, maybe not. Maybe you can describe, that everything's sealed, and then that the seals meet a certain standard, and therefore you reasonably wouldn't have anything coming off site or anything exposing employees. Yeah.
The Chapter 9.44 has a minimum of what's required for all commercial cannabis businesses, so I would, at the minimum, make sure that you're illustrating that you meet those requirements and how you meet those requirements. speaks to some sort of air suction thing. I don't know.
Sure. It also seems to say that there's no detectable odor outside.
Right.
Until you actually have a facility filled with retail goods, do you know if there's an odor outside?
I would say when I think of air quality, I think of indoors for your employees as well, especially like a manufacturing facility. A manufacturing facility has scrubbing equipment and recirculators and you name it. That seems to be a industry practice. You don't really see the same thing in a retail environment. But keep in mind, air quality is also for your employees and concurrently for your clients.
So I wanted to go back and kind of clarify the ranking. So let's just use the easy example. 3 people get over the 90% and say the first one has a 98, 95, 93, right, score. That 95, if they're within the distance to, say, the 98, are they going to get a chance to move, or are they just out?
They're just out because we can't go back and redo the whole process again with regards to the public interviewing process.
Is there going to be a chance to apply for permits on an annual basis every year?
Correct. There will be another cycle of some sort.
Okay. And is it mandatory for our non-retail businesses to have a sign? Because they asked for a sign.
I believe
plan.
I believe that a wholesale facility would be nondescript. I would have to read the code again, but it's my understanding that wholesale facilities are so undescript that you wouldn't know what's inside.
I don't believe the code says that they have to have a sign. It's just if you have a sign, we want to make sure it's compliant with our sign ordinance.
If you plan on adding a couple more dispensaries, when will you know how many? Just because it will affect the pro forma and those stated numbers.
Like new dispensaries coming online in the
Correct.
future?
Like
that would
regard
be
to the
for the mayor and council to decide.
Okay.
That is solely to their discretion. So city staff would not know when or be able to opine when council would want to do something different than they're doing right now.
Okay, so in regard to pro forma, do you want us to assume that there will be 3 dispensaries?
Yes.
Okay.
Or I should say no more than 3. You know, is it possible that only 2 dispensaries were qualified? Sure.
On the permitting fees, when you have the annual permit renewal fee, is that paid up front year 1 or is that for year 2, and when is it due?
I couldn't tell you. Tava, do you know?
So can you get to the fees
Sure.
so I can see them? So if you are selected for issuance of a city permit, you will pay upon issuance the initial year compliance fee, and that will cover you through that first year, and that fee will include the auditing. The significant portion of that fee comes from our outside consultants that we use for financial auditing. And then every year after that, you'll be paying. That's $7,300 if you're a non-manufacturer.
Next question.
Primarily to clarify potential ambiguity, I just wanted to confirm that the 90% minimum score is for storefronts only and not delivery retail.
90% minimum is for everyone. You have to get at least a 90%. And if you get a 90% and you are apart from a storefront retailer, the city administrator may issue your permit. It only becomes an issue with regards to ranking and tie breaking with regards to that we can only have 3 dispensaries, and if everyone in this room is applying for the storefront retail dispensary permit, obviously we have to have some way to take the top 3.
Is there a particular order that we submit documents in, like online? Kind of the same order that you've got laid out?
So that's actually a really good question, and I was trying to get a hold of the person from Planet Bids. The way I think it would happen is it would be a complete packet, and what you need to do for us, you can see, and we have checked the boxes on the application that says you have to have your neighborhood compatibility plan, you need to have your air quality. I can see it as submitted as one giant bulk document, but it's got to have some way, like an index for the people that are reviewing it to be able to check quickly and see that you've got everything and your application's complete. Have you used Planet Bids? I've never.
I just took a bite of a cookie.
Sorry, Andrew.
No, not risking my career on that. I have no idea.
Okay. So I did see that there's 3 outstanding questions on Planet Bids, and one was a question like what you just posed. When I get a hold of the Planet Bids guru, I will post that in the question and answer, so it'll be a straight answer that you can all look at.
Yeah, that's a question for Bill, and he can put that on Planet Bids.
Will you allow, maybe this is, will you allow multiple licenses in the same site?
Correct, yes.
Okay, so because I'm just wondering if there's a landlord and he has like multiple.
Correct.
So there could be,
yes,
know, applications with many different landlords.
In a manufacturing facility in the proper zone, you could have a space that has many different offices, a distributor, potential for a manufacturer,
Great, okay.
Maybe a small cultivation, yes.
And I guess the same question for the retail. So say a landlord is like, sure, I'll sign your form, whichever one of you gets the retail thing. Would that also be okay?
Yeah, that's unfortunate, and that's actually happening. That's been a couple questions
I assumed
that
it would happen.
I believe there's one retail entity that is basically taking the highest bidder. So
yeah,
correct,
okay.
that is
so
happening.
It is allowed.
Yeah.
Yeah, okay. Thank you.
Sorry, I might have done this before. About the architectural drawings, do you need a floor plan of the entire building or just the area that we'll be operating within? I mean, I know you need a site plan for the whole building, but do you need a floor plan for the whole building?
No, similar to a tenant improvement, you'd need a floor plan just for the area that's going to be occupied where you'll be making TIs and you'll have a security plan, but for anywhere that you wouldn't have access to your business, there's no reason to include that on the floor plan.
What restrictions or criteria is in place for prospective employees of a cannabis business?
Well, there are state criteria and local criteria that you can't be convicted of some types of felonies, and you have to be able to pass a live scan. I can't hear you. Say it again.
And be over 21.
Be over 21. And all of that exists currently in the state code, and then there are some portions of section Santa Barbara Municipal Code section 9.44 that call that out as well. Gentleman in the back.
Yeah, what if there is a residence above one of the commercial zones? I mean, it's in the zone, but what if there's residents paying rent upstairs or in the same building?
Residential areas are not sensitive receptors.
But if it's a commercial zone, but there's somebody living paying rent in that zone, is that still okay if they're in the correct zone?
I'd let Andrew answer that.
Yeah, if you're thinking of, say, a mixed-use building where you've got commercial on the bottom and like condos up top or apartments, and someone's wants to move in and have a retail business on the ground floor, even though there's people on top, there's no problem there. There's no zoning conflict.
When will you be scheduling the first walkthroughs?
The walkthroughs for, I couldn't tell you that right now. I would probably have to see after the. Go ahead, Teva.
After the public interviews, there'll be the applicants will be notified of when we'll be doing walkthroughs.
If there are residential units above a unit that's zoned, do the residents there have the ability to oppose?
Absolutely, sure. Yeah.
And that supersedes?
Well, it definitely is taken into consideration, I guess, at the interview. Constituent feedback is very important to city staff to ensure that we find the right partnership that meets the needs of the entire constituency of the city.
I'd add only that the neighborhood compatibility component becomes much more complicated when you have nearby or, say, on top of residences. So showing in your neighborhood integration plan how you're going to accommodate and be a good neighbor to like very close proximal apartments is going to be pretty important in that scenario.
It seems like if there'd be, I can think of a couple components in my head to where I would think inherently it would be unsafe to have people on top of the building, maybe like closed loop manufacturing or something like that. That seems to me that would be a public health and safety issue.
Did we answer?
What are the CEQA requirements, or will there be an exemption? Yeah.
Yeah, it's 15183. Yeah.
So I just wanted to clarify, two different applicants can apply for the same location. Is that what you said?
It's been presented to me via phone in questions that there are landlords here in Santa Barbara that are negotiating with multiple different tenants. That's what was presented to me by some questions of people in the room here.
So if two different applicants are down to the final three, or say two, and they're fighting for the same location, how do you determine? I mean,
I don't have an answer for you.
Well, between them, it would be the highest scoring would be issued the permit, and then the second one being within 1,000 feet in the exact same location would be disqualified from further review.
If the applicant owns the building, is there any preference for that versus leasing?
There's no preference to city staff, but that seems like that would be the safest venture for an actor to not have an adversary relationship in the future with their landlord by the landlord being able to charge accordingly.
Have we answered everyone's question?
I think Mr. Mahboob had another question.
Oh,
I'm sorry. If you had multiple applicants out there with a minority interest in it, is that allowable? Let's say someone that owns 10% of one of the dispensaries but wants to apply for two different locations.
Yeah, there are state thresholds. I'll have Teva be able to answer the intricacies of your question.
So For our purposes, we just want to know who has the controlling interest, who's the responsible party. Our code section sets forth, if it's a corporation or limited liability, what that interest is and when we need to know who they are. But there's no, from our code section, we don't tell people that they can't have interest in one or more.
Perfect. Last call on questions. We will stay after if you have anything else. Tava, do you have any parting words?
Just that this is being recorded and it'll be on the website. We also adopted resolutions with some operating procedures that set forth operating hours for retail storefronts, so you should take a look at those.
And I would just say one last thing before Andrew says his thing. Be very cognizant of the ex parte communication. It's one way that would negatively influence your application. So now is the time to ask a question with us, or your next avenue after tonight is to answer it through Planet Bids. But an email to a council member, an email to a member, mayor, email to anybody outside of Planet Bids will negatively influence your application. Yes, ma'am.
That the zones could be increased in the future?
Same question with regard to number of locations. I would encourage at some future date to have you have a conversation with your council member on that.
I'll chime in also that council directed staff to return to them in the future with an analysis of adding the commercial manufacturing zone, CM, on our zoning map as a zone for all cannabis businesses. So that will be coming later this year to council, and if they adopt that, then that expands the allowable zone subject to their action.
Tava, you may have answered this already. Now, you want to see the full package handed in, because when it talks about phase one, it's just 1, 2, and 3, zoning verification, licensing, etc.
Yes, by March 30th, we want the whole package uploaded into Planet Bids.
Got it. Thank you.
About the operating hours, is that solely for, like, actually the business being open to the public, or is that the only time at which someone can be in the business working? Meaning
Two different
deliveries
operating hours.
happen before operating hours.
So your 10 to 10, I believe, is in the ordinance for retail operators. There's 24-hour capability of working, or whatever the zone says.
You could have shipments delivered prior to 10 a.m. is basically
Correct.
what I'm asking. Okay,
Yeah.
thank you.
I just would want to clarify that you can't conduct retail sales between the hours of 10 p.m. and 10 a.m. Correct.
Can they do deliveries or have employees in the store doing inventory, things like that, outside those hours?
I would defer to Tava, but I would also clarify that wholesale type activity does not have hours of operation.
That's not my question, but
So you're asking if you could have employees in the, if you, I'm assuming you're referring to storefront retail.
just to make sure it's okay to have employees in there.
I'll post the resolution onto the website, but I believe it's drafted that it's open to the public.
Okay. And on phase 3, will the public be when will you be notified, I guess, of when the meeting's going to be, or what your presentation time limits, things like that might be?
As soon as we've finished reviewing and determined who's 80% or better, we'll do everything we can to get those notices out right away, so at least you know you're moving on. And then we should be able to have the setup. So we don't know how many people will get above 80%, so it's hard for us to figure out how to schedule that right now. Okay. But we'll send out the procedures and what we're expecting as soon as we can.
Ryan, you have a last question? And did you have something else?
I just want to thank everyone for coming and for being patient. And if you've got questions that you didn't want to ask in the group setting and recorded and you just want to ask them individually, we'll have a few minutes to do that. Otherwise, please take some cookies on your way out and have a good evening. Thank you, everybody.